All right,
Yes,
good morning, everybody. This is Judge Torm on behalf of the Energy Facility Site Evaluation Council. This is the third pre-hearing conference in the matter of the Scout Clean Energy and Horse Heaven Wind Farm project. We have an agenda that has been circulated. I hope everybody on the line has that. Again, for members of the public who might be listening in today, this pre-hearing conference is for procedural and other pre-hearing, pre-adjudication discussions, and we're not going to have an opportunity for public comment today. With that, we have 7 items to go through, the first of which are the appearances of the parties, and I'll just call the name of the party and let you speak to who all is on the line today and who will be representing and speaking on behalf of that party. Let me start with the applicants.
Good morning, Judge Torm. Tim McMahon here, and I'm here with my colleagues Emily Schimmelfennig, who's calling in from DC, and Ariel Stavitsky, who will be stepping in to assist us. I think you have the spelling of her name. If not, Ariel can do that herself here orally.
Ms. Stavitsky, can you confirm it's S-T-A-V as in Victor, I-T-S-K-Y?
That's right, Judge Torm.
Perfect. All right. Thank you, Mr. McMahon. For Benton County today.
Good morning, Your Honor. You have Ken Harper and Z Foster.
Mr. Harper, your sound level's pretty low. Can you repeat,
okay,
please?
I'll try to speak up. This is Ken Harper for Benton County, Your Honor.
All right. And you have Aziza Foster with you as well?
That is correct.
All right. And we don't expect Ryan Brown from the prosecuting attorney's office to participate today?
No, I don't think so.
All right, perfect. For Counsel for the Environment.
This is Sarah Reineveld for Counsel for the Environment.
Thank you, Ms. Reineveld. For the Yakima Nation.
Thank you, Your Honor. Shona Volkers for the Yakima Nation. I also have my colleagues Ethan Jones and Jessica Houston on the line. I just want to note that the sound is breaking up a bit on my end. Thank you.
All right. Hopefully that's not being caused by my connection, but you're coming through loud and clear on this end. Finally, Tri-Cities Cares.
Good morning, Your Honor. Richard Aramber representing Tri-City Cares. There is also on the line numerous members of Tri-City Cares. However, they will not be participating in the hearing this morning per your direction. Thank you.
All right, thank you. I'm going to now ask if we have from the Attorney General's office, John Thompson, or anybody else with him.
Yes, this is John Thompson, Judge Torm.
Anybody else participating from the AG's office today?
Yes, I think my colleague Jenna Slocum is on as well.
Yes, good morning.
All right, thank you. Good morning, Ms. Slocum. Any FSEC staff other than Joan Owens who have already identified? Do we have Lisa Massengale listening in?
This is Lisa Massengale, present. Thank you.
And do we have Andrea Grantham?
Andrea Grantham is present.
And I know I don't have it listed on the agenda, but do we have Amy Haskmeyer? I thought maybe she'd be on today, but she may have other issues for citing to go on. Do we have Alex Shiley?
Yes, Alex Shiley present.
Excellent. Anybody else that I need to acknowledge is present from FSEC staff? This is your time to speak up. All right, hearing none, let's move on to item number 2. When we were last scheduling this pre-hearing conference number 3, we had asked the parties, or I had asked the parties to submit their letters regarding preferences for the type of adjudication. And you all have to know that your letters were read, considered, discussed between myself, the FSEC Director, Ms. Sonia Bumpus, and Chair Kathleen Drew. And you all received a response as to the venue, and Chair Drew explained why it's going to be held virtually. And we're going to be using the platform with Microsoft Teams. with an option for call in, if you'd like, as I'm using it today, just calling in without using Teams. At the last FSEC meeting in April, I attended in person at the UTC offices in Lacey to see kind of the magic behind how the virtual proceeding will occur. And I'm satisfied that with the assistance of FSEC staff, we'll be able to have a smooth virtual proceeding. There are still some challenges, and we'll work those out a little bit later, particularly those raised by the Yakima Nation on testimony and participation from tribal elders. There will also be some questions on how we're going to work with exhibits. Those matters will have to be taken up as we get closer to the hearing itself. And we'll go from there once we get to that point. Did any party have a question about the choice by the chair that we're going to be doing this virtually? Let me ask first for the applicant, any further clarifications on the venue?
Thank you, Your Honor. The venue is clear to us. Appreciate it.
All right, for the county?
Ken Harper for the county, no questions, Your Honor.
All right, Ms. Reineveld, on behalf of Council for the Environment?
No questions. Thank you, Your Honor.
Ms. Volkers for the Yakima Nation?
Thank you, Your Honor. We do have concerns, and I think that, as you said, we will be addressing those later. I do not have any questions, just concerns and a general objection. Thank you.
All right, and I'm happy for any party that has a formal objection to make that at the appropriate time, and I'd ask that it be done in writing so as to preserve it for the record going forward, not only for this adjudication, but any appeals taken from any recommendation made to the governor. So there will be transcripts of this, Ms. Volkers, but I think it'll be best when it's appropriate to either note that in the formal motion or just a written objection for the record. Is that okay with the Yakima Nation?
Yes, thank you, Honor. We do plan to do that.
All right. Mr. Aramburu, on behalf of Tri-Cities Cares.
We continue our request for some portion of the hearing to be in person. We are also going to submit a request for an additional site visit to the property and the site of the facility. We think the original site visit, which was conducted outside of the adjudication, was not sufficient. So we're going to request an additional site visit, which might be held in conjunction with some hearings in the project vicinity. And so I guess that would be formally an objection to all of these hearings being held virtually.
All right, and I appreciate your additional comment about it being perhaps styled best as an objection. I think the additional site visit request might be outside the scope and of an objection, Mr. Aramburu, but I leave that to you on how you'd like to submit those, whether it's one objection for the record with that request or a separate request formally to the council and the chair to explain why an additional site visit might be best for purposes of creating the record for the adjudication in the matter.
I'll make a independent request for a subsequent and second site visit, and that will be forthcoming soon. I just want to alert you, the council staff, and the parties of our request.
All right, I do appreciate that. It will help build in a later discussion today as for the timing of that request and when you would file it, but also the timing of when you're requesting the additional site visit based on us shifting now to item number 3 and the scheduling of the adjudication. I was glad to not get you this pre-hearing conference agenda 10 minutes before the pre-hearing conference this morning. So I'm trying to keep my promise to you to be a little bit more ahead of my schedule than 15 minutes. So you've got these proposed dates and the explanation of what's going on. I'll let Mr. McMahon update us on any discussions about the third extension request that's still being negotiated with FSEC staff. And then we can talk a little bit more about the dates for the hearing. Mr. McMahon, do you have any updates on the current applicant's proposed extension that's with the council?
Thank you, Your Honor. Excuse me. Thank you, Your Honor. We did have a good conversation with FSEC staff last week, I believe it was, and we are in discussion, and we understand the issue, and we're working on resolving it. So that's about all I can say at the moment. But do trust that we are taking it seriously and it's in consideration.
When you say we understand the issue, can you just elaborate a little bit more? Because I'm not privy to those discussions necessarily, and neither are, I don't think, any of the other parties. So I don't want you to disclose anything that's, just between the applicant and the council that you think is not disclosable yet or not ripe for talking about. But I do want everybody to be on as much of the same page as possible as to scheduling.
Sure, Judge Torm. I don't know that I have too much more to offer. We do understand the pressing nature of concluding the adjudication and time for the council to fully deliberate and to complete all aspects of the project, including the environmental impact statement. So we did, FSEC staff did share with us timing for the actual deliberation that follows up on the schedule that you have here. And we have committed to work with staff to flush out and expand, hopefully, that time frame after August 25th with a conclusion of the adjudication. And it is not our desire at all to leave the Siting Council in a position of having to really, really rapidly deliberate to a conclusion here. So I guess that's really all I have to add at the moment. This was a very, a conversation that we just started, at the end of last week and early this week.
All right. Thank you, Mr. McMahon. I think that's a good point for me to point out that we canceled the third pre-hearing conference that was scheduled to go forward. I think it was March 27th. And we did that so that the chair could respond regarding the virtual venue, as well as to have some discussions between me and FSEC staff and the chair and the director as to my push for this and strong suggestion in the past for Mr. McMahon and Ms. Chase at the time to submit a further extension beyond July 8th. And my suggestion of the September 30th date that was, I think, captured in what Ms. Chase announced during the second pre-hearing conference. There was some indigestion at the council as to whether my assumption that would be enough time would allow for all the things that Mr. McMahon just stated. So based on that, we struck the pre-hearing conference until some of those issues could be better worked out and a better mutual understanding of how the two-track process between this adjudication and the separate SEPA process for the final environmental impact statement to come out, if September 30th would be a sufficient amount of time for that. And again, those discussions are ongoing. And I just wanted everybody to kind of see a little bit behind the curtain why procedurally we're having pre-hearing conference number 3 over a month after the momentum we initially established in March. So I'm still pushing that the adjudication stay on track and we use the dates that are now discussed there. What we've laid out based on your filings of unavailability and other inputs from council members and council staff are the dates you see in bullet format on page 2 of the agenda. 2 days in a row will be held August 10th and 11th. The next week we'll have another 2 days and a half, Monday, August 14th, 15th, and 16th. And given the monthly council meeting scheduled regularly on August 16th at 1:30 in the afternoon, my discussions with the chair and staff indicate that one morning session, it might even be a longer session than suggested in the daily day schedule, a little bit below that on the page, would be sufficient for everybody to be able to concentrate and focus and turn their attention to the monthly council business in the afternoon. And then we'll have a full week, Monday through Friday, August 21st to August 25th. A lot of the scheduling of who is going to testify for cross-examination on any given day and what topics are going to be discussed on any given day. I have some ideas of how long each topic may take, but they're not going to be any better informed than anybody else on the line until we see the pre-filed testimony and any stipulations that may occur. So we'll do some formal scheduling of how to best use those 9.5 days of hearing time by assigning topics and witnesses. A little bit later, we'll have another pre-hearing conference to sort out your witnesses' availability and what dates might be best for grouping topics. Let me go around the room and see if anybody has any concerns just about the dates themselves, and then we'll shift to kind of my suggested daily schedules and timing and take your inputs on that as well. So let me go back to the applicant and see if there's any questions about the dates or comments that might be applicable to scheduling.
Tim McMahon here. No, we don't have any questions or comments, and we believe the schedule appears to make sense.
All right. For the county?
Well, Your Honor, I think it's difficult to comment on the acceptability of the dates because there's a lot of other issues that that we think have to be sorted out before this is appropriate to commence. I think you understand that. I'm sure you understand that, and there's no reason to inject that kind of discussion. I think what you're just looking for right now. As to the dates per se, I have no objection to those, and I just like to express that our other positions we would like a chance to discuss at some point as well.
All right. Thank you, Mr. Harper. I appreciate focusing on the dates only right now. And you let me know when you think which part of the agenda you want to bring up those other issues and questions.
Sure, I will. Thank you, Judge.
All right. Thank you. Counsel for the Environment, any comments or thoughts on the dates themselves?
Yes. Unfortunately, I'm going to be on vacation on August 10th and 11th. My schedule was in flux and we recently confirmed that trip. So I had not yet had a chance to submit my unavailability. I mean, it's possible I could participate from Hawaii, but I did want to bring that to Your Honor's attention.
All right. I'm making a note of that, Ms. Reineveld, and it's possible that CFE may not be a lead participant on a particular set of topics. I'm not sure exactly what those might be, but you may find that you're willing to defer to another party that has overlapping or exactly the same interests. My only concern is that Counsel for the Environment may be a mandatory party by statute, particularly on any environmental topics, which, depending on your interpretation, could be every topic at the hearing. So I want to make sure that by statute, your office is represented at this hearing. I don't want you necessarily to be forced into a appearance with the 2-hour or 3-hour, as it may be, time difference, and what you've planned for personal time taken away from family. With that said, unless we find that we don't need hearing dates as all planned out, this may be a discussion for you to have with your supervisors through the AG's office or your colleagues who are also Counsel for the Environment on other matters, so that at least one CFE is present on August 10th and 11th. And if it has to be you calling in from afar, that's something we can talk about as we get closer and sort out the issues I just at first blush see in your potential conflict dates. Does that make sense, or anything else you want to add to that?
That makes sense. I just wanted to notify the court, and I am available for the rest of the days. I don't know if another Counsel for the Environment could participate just because of my unique knowledge of the matter, but if absolutely necessary, I could participate via Teams.
All right, thank you. And since we're doing this virtually, at least that allows this platform to have a virtual appearance even from afar. I appreciate the heads up on that, and I've made a note.
Thank you.
Ms. Volkers, on behalf of the tribe, any concerns about any of all of the hearing dates?
Thank you, Your Honor. A few thoughts. I know that we talked previously about a 2-week hearing, and I think that, like Mr. Harper, it's hard to speak too much about the hearing logistics without having some of these other issues resolved and clarity on, how many witnesses we're going to have. But and we're now taking up most of August for a 2-week hearing because of the way that's split up. So I'm just a little concerned that that's cutting further into the schedule before it. And I don't know if that is necessary or not. I do think it's important that Counsel for the Environment attend all of the witness testimony by my client, as those are important issues. And I know that that Sarah takes it very seriously. I just wanted to make sure to note that that is those are issues that we consider important for the Council for Environment to include in their assessment and position. And I want to just appreciate the clarification regarding the last month's silence, but I would say that it's unclear to me what would not be appropriate for Tim to share from his conversations between him and FSEC staff. I think we're all very interested in how this is progressing, and I don't know that there's any real confidentiality around the applicant's conversations with staff on things that are impacting our schedule. So I just want to note that I do have a concern that conversations are happening that are not including all the parties on that topic, and likely are including a discussion about the SEPA timeline, which we've asked for separate from the adjudication. We've asked for that timeline a couple times. Thank you.
Thank you, Ms. Volkers. I'll at the end, once I've asked Mr. Aramburu about his items on the dates, I'll come back to what you said about the discussions with the applicant and then go back to Mr. McMahon to make any further clarifications as needed. Mr. Aramburu, any comments for TCC on the dates?
Thank you, Your Honor. Several comments. First of all, we think that discussions between staff and the applicant should be fully disclosed and available to the parties so we understand what's going on. Issue one. Issue two, August, Your Honor can take judicial notice of August being a time for vacations in the Northwest. I would not want to delay identification of when individual witnesses might be asked to be available for cross-examination to some date a month and a half or 2 months from now. I think that needs to be resolved early. Number three, we have a strong objection based upon what we've heard so far, that the final impact statement will apparently not be available during any part of the adjudication, any part of the direct testimony or cross-examination testimony. We think it's very clear that the council needs to work around having the final impact statement available for the parties to use in these proceedings. So, and we have inquired, as you're aware, about the timing of the final impact statement, and we've received no substantive information regarding that. Fourthly, to the extent that our dates for cross-examination, and that's what I think the hearing dates will be, although we haven't finally decided that, I think those need to be set by the scheduling for testimony and other procedural matters rather than backing into those matters based upon these dates. So we have strong concerns about the filing deadlines in your paragraph number 4 of the agenda that we're going to express at the appropriate time. But we do think hearing dates need to be set following a reasonable schedule for filing deadlines in item 4. So those are our concerns. And we have to the extent staff is on this call, we have a continuing request for some indication of when the final environmental impact statement is going to be available so that we can do some planning around that. So those are my comments. Thank you.
All right, and I want to give Mr. Thompson a heads up that I'm going to ask him to address the nature of the ongoing discussions between the council and the applicant, and how those fit into the overall application review process, and what the nature of those conversations might or might not be for public disclosure. So I'm going to give Mr. Thompson a chance to think about that before I come back to him. As far as the vacations up for witnesses, my advice to all the parties is to give your potential witnesses, who I'm pretty sure you all know who you might be calling, these hearing dates and get their unavailability, so that once we know exactly what topics might be scheduled on what dates, we can take that information into account and make sure that parties are able to best present the witnesses that they'd like within the confines of this schedule. If you look at the top of that item number 3, it says that these hearing dates are firm, and I want to keep to this schedule, and I may be forced to keep to this schedule without exception, simply because of your availability as a group and the availability of council members as a group. So scheduling is a tough decision for a lot of court cases, and it's no different from SSEC, and it may be even that much more difficult because of the varied parties included at all of these issues, dates, calendaring, and then of course the statutory restraint on trying to get everything done in the legal fiction, as we know, of a 12-month period from application to recommendation to the governor. All of those things create conflicting pressures for scheduling, and frankly, this is the best that staff and I could come up with, and that's why those dates are going to be firm, unless, again, if there's good cause and availability, maybe there can be some exceptions or accommodations made for a particular witness on a date outside of these. But these are the dates we have, and we're going to be going to through the adjudicative process with the best dates we have available. Now, as for the scheduling below, we're going to talk about the day-to-day housekeeping schedule in a moment, but I do want to also address the final environmental impact statement that I know PCC and perhaps the county and the tribe, and maybe even Council for the Environment, are asking to be completed prior to the adjudication hearing being held and/or before the adjudication is completed and the council and staff begin their deliberations on all of the evidence and the SEPA process before the recommendation is made to the governor. My suggestion to you, Mr. Aramburu, I know you've had correspondence with staff to seek out the best available information on when the SEPA process will be complete and how that will be interwoven with the adjudicative process. As necessary, as we talked about previously, filing objections and preserving issues for appeal. And as I think I hinted later on in the discussion of disputed issues, any concern you have about the timing on that is probably best preserved in a motion or a stipulation that there's a standing objection without me having to rule on a motion. There are some other precedents out there, whether they're still good law is something for you and your similarly situated parties to consider, and either jointly or separately file the motions you deem fit so that I can get responses from the applicant and then issue an appropriate ruling. Some of those things are outside the adjudication, in my opinion, but again, a formal briefing or a motion with briefing and support will let me know if there's something I'm, in my experience, overlooking, so that I can hear from the applicant and hear from all the other parties on those issues, depending on who's filing the motions and who's responding in opposition. So that's my suggestion on the final environmental impact statement questions that you've raised, and I expect we'll continue to raise throughout our discussions. And so with all due respect to that, let's put that in a place where a formal ruling can be made and the council and all of us as parties can move on toward what the adjudication holds. And again, whether it's delayed or held on behalf of the final environmental impact statement, no final decision on that until I get a formal motion. Mr. Thompson, let me ask you to come on, if you would, and just state your best understanding of the nature of the ongoing discussions between the applicant and FSEC staff and how those fit into the overall application review process?
Yes. So the discussions we've had are sort of just in the context of regular check-ins with the applicant in regards to the ongoing SEPA process and the data requests, which I believe are posted on the FSEC website, so that folks can see what the kind of ongoing issues are in terms of developing adequate information for the final environmental impact statement. So there's that discussion, and then there's because as people know, under RCW 8050-100 sub 1A, there's this requirement that the council shall report to the governor its recommendation as to the approval or rejection of an application for certification within 12 months of receipt, or at such later time as mutually agreed to by the council and the applicant. So the conversations have just been limited to us laying out how we see these dates, which are now set forth in the agenda for this pre-hearing conference, and basically thinking through, what we would need after completion of the cross-examination hearings in terms of time for, getting back transcripts, parties, preparing post-hearing briefs, and then just a realistic time frame of maybe, a couple, maybe between 1 or 2 months thereafter for the council to be able to have time to deliberate and develop the adjudicative order, and then the recommendation to the governor with the input from also from the SEPA process. So just thinking through, like, how long is that all going to take, and what would be a realistic date to try to come to agreement on for the under the statutory deadline for completion of the recommendation of the governor. So there's no additional detail other than us just presenting those considerations, and I guess the applicant thinking about what they're willing to put forth as a agreed extension.
All right. Thank you, Mr. Thompson. I think, again, what I'm hearing and what you're clarifying for me is that these are procedural discussions and substantive only in the matter of what data requests might be out there and when studies might be completed to supplement what was in the application and the draft EIS. But there's nothing going on about the adjudication necessarily, other than how everything fits together for that ultimate recommendation to the governor. Is that correct?
Yep, that's 100% accurate. Yes.
All right. Let me ask Mr. McMahon on behalf of the applicant if there's anything else to say about those discussions and the nature of them, and perhaps, as Mr. Aramburu is implying, you're giving a cryptic response about things, but based on what Mr. Thompson said in my summary of it in 2 sentences, did the applicant have anything else to add?
Thank you, Your Honor. Tim McMahon here. Mr. Thompson accurately described the ongoing process, which is fundamentally procedural, between the applicant and FSEC staff. I do, though, want to make one clarification, if I may, about the status of the final impact statement. And if I got my notes correct here, you indicated that it would be necessary to, quote, hear from the applicant, end quote, regarding FEIS timing. I want just the parties to understand that we are in no greater control over, or guiding in any way over the timing of the final environmental impact statement. That is entirely a state process and a state document, and we are not driving that boat. So I want to make that very clear. To the extent there are objections about how the FEIS interplays with these other processes and the timing issues, that is fundamentally a state issue. It is not the applicant's issue. So I want just to make that very, very clear to the parties.
All right, thank you, Mr. McMahon. I appreciate that clarification. I wasn't implying and anybody else's control over that than the council and their contractor handling the creation of the environmental impact statement documents. What I meant by saying I'd like to hear from the applicant simply was if there's a motion to stay the proceeding or any other such thing regarding the EIS process and the SEPA process, that of course the applicant would be another party entitled to file a response, including one that might just say that's up to the state. But I would want all parties that are opposing a motion to have an opportunity to be heard within whatever schedule we have, probably a few business days after anything is filed, depending how it fits the rest of our schedule. All right, I'd like to move on here. It's now almost 10:40 and plan in advance for a break at the top of the hour for about 8 to 10 minutes for comfort or discomfort, as one might see, and to give the court reporter a break as well. But I think we can move into the second part of item 3. My proposed schedule, and this is notional only, for breaking up testimony sessions into 2 hour blocks at the lengthiest and having at least a 15-minute break between each block of time. My thought is 8:30 as a start time for just having an optional pre-adjudication but on the record discussion of any preliminary motions. Seems to be a day-to-day thing. We could talk about making sure everybody has exhibits that might be used that day. We can talk about any minor adjustments to the schedule for the day or known problems that are coming for a later date, and then be ready for testimony that we would schedule again from 9 to 11 with a long enough lunch break for folks to get away from the screen, and then starting up again after a lunch break, and then leaving a little bit of time for folks to caucus between their witnesses coming up or witnesses that might have ongoing testimony, and for the parties that are aligned with each other to off the record have whatever caucusing they need, as like you can see between 1:45 in the afternoon and 2:30. And then having that last session so we're not fully exhausted by doing the virtual process for too long, so eye strain and just brain strain from litigating for 3 sessions a day. Maybe as needed to finish a witness, we would stretch past 4:15 to 4:30, but that's my suggestions on timing. And the experience I've seen and from other folks being in long virtual hearings that go for almost 8 hours a day, and the physical and mental impact of exhaustion on that. That's why I'm selecting this kind of a notional schedule. Some of you may have more experience in these virtual hearings than I, so I now want to kind of go around the room, and you can see the italicized language I have about breaks within those timing suggestions, and I'll ask each of you for your inputs on the length of those sessions and whether you think that's too much or too little, and then I can adjust accordingly based on your inputs. So Mr. McMahon, on behalf of the applicant, any inputs on the day-to-day scheduling as suggested?
Thank you, Your Honor. I find that to be a very humane looking schedule, and I'm a big fan of bio breaks. So I think that's I think it's a fine schedule.
All right, Mr. Harper?
Ken Harper for Benton County. I have no concerns about the proposed daily schedule.
Ms. Reineveld?
Yeah, I appreciate the breaks in here as well. I guess I just had some questions. As the witness exam 1, is that supposed to be one witness and they're supposed to be done in that prescribed period of time, and then you're calling additional witnesses, or is that just the exam period that will go on as long as we need to for a particular witness?
Those are good questions. The numbers on there are just session 1, session 2, session 3. Some witnesses might only take 30 minutes for everybody to be done with their cross-exam. Some may take 4 hours. I just don't know quite yet, Ms. Reineveld. So those suggestions are just bumpers on, as Mr. McMahon said, a kind of a humane amount of time to go at a virtual hearing session. So somebody may carry over or not. It just will depend on the needs and the estimates we get once we identify the witnesses. Does that answer your questions?
Yes, it does. I think witness exam 1, 2, and 3 might be slightly misleading because at least it implies to me that they're different witnesses, but as long as it's a clarification that the witnesses will be scheduled and cross-examination will continue to the length it needs to be for that individual witness, I think that's fine. Thank you for the clarification.
Yep, sometimes words carry different connotations, and I can see how you could read that either way. So I'm glad we got that clarified today on our pre-hearing conference record. Ms. Volkers, any additional concerns or otherwise that haven't already been stated?
Thank you, Your Honor. No, I agree with the approach of having the time of the witness be dependent on their testimony. If I could, I just had one more thought on 3 above, and I didn't want to interject and interrupt anyone earlier.
Okay, go ahead.
I guess what I was trying to get at earlier was and I appreciate all the explanations, and certainly I'm not concerned that the applicant in general needs to talk to FSEC about their application. My concern is that if the FEIS isn't actually going to be done for another 6 to 8 months, putting aside the procedural SEPA discussions or motions that might happen, and with understanding that FSEC is still going to need time to review everything, I'm concerned that there's maybe a missed opportunity here to give as much time as possible to create the best record as possible, and also to avoid summer vacations and all of that. And so that was what I was trying to get at, with concern that we don't have an FEIS schedule. Staff might have a better idea of that, and but if the idea is that this is going to take time, a significant amount of time, then my concern is that we're not having that timing worked out in a way that informs the scheduling of the hearing. So thank you for letting me articulate that. I don't have any other concerns about the daily schedule.
All right, thank you. Mr. Aramburu, anything else on this daily schedule or in response or addition to what Ms. Volker said about the FEIS?
I guess my observation would be that you're intending to start evidence or testimony cross-examination at 9 a.m. Because a number of us have other things that we'd like to take care of in the morning. I'd request that we start at 9:30 a.m. instead of 9 a.m. I think we have sufficient time set aside. We have 10 full days of testimony, and I don't think we're going to need all of those. Also, we'll observe that Ms. Reinefeld, if she's in Hawaii, that will be 6 a.m. in Hawaii. So I would request that we start at 9:30 a.m. And this does kind of make for a long afternoon if we're breaking at 11. So because we're going to go from 12:15 to 4:15. 4 hours, but only a shorter time in the morning. So 2 requests or suggestions, Your Honor. Number 1, start at 9:30 to accommodate other things in people's lives, and number 2, move our lunch break so that the afternoon session is not quite as long. So those would be my suggestions, Your Honor. Thank you.
Mr. Aramburu, can you clarify when you say shift the lunch break? Does that mean at the expense of time in the afternoon? Tell me what you mean by that.
Having the lunch break from 11 to 12 means the afternoon session is going to be pretty long, and people tend to be more tired in the afternoon than in the morning. So moving the lunch break to 11:30 or 12 o'clock would shorten the afternoon session a bit. And give us a bit more time in the morning. So that's my request.
Okay, that helps me understand that. I do agree with you that people are a little bit more bright-eyed and bushy-tailed after a few cups of coffee in the morning, whether that's at 9 or 9:30. I can take that into consideration. And I do appreciate that the afternoon may be challenging to run things from 12:15 to 4:15 or 4:30. And I tried to figure out shorter periods of time, as you can see the number of minutes set out parenthetically, for exactly that reason. And it was difficult to figure out how to build in 3 sessions and a lunch break and not run up to 5 p.m. But that's still an option to rebalance that, but still fit in a sufficient lunch break. But I do appreciate those inputs, and those were some of the things I had discussed with Mr. Thompson and other FSEC staff as we kicked around this notional schedule. So I'm going to take those things into concern and consideration as we get to the point of actually setting the exact daily schedule on the dates noted above and further up in number 3. All right, we're getting close to a good point to take that bio or discomfort break, as we might call it. I do want to kind of preview that we'll go over the filing milestones in number 4 when we come back on the record. And I want some inputs a little bit on when that first evidentiary data drop will occur for pre-filed testimony later this month, whether that be on May 24th or if we want to go to May 31st. I'll also be asking for your inputs and thoughts on the time interval between the rounds of pre-filed testimony. If all parties agree that they can be compressed in response from the 21 days allocated, then maybe we can delay filing of the initial pre-filed testimony into June. But I think that having it all filed by mid-July is something that will allow parties to have a time for motion practice in the latter half of July and up until early August to make this happen. So there'll be some rapid filing going on and rapid fire responses based on how many motions we get. And there may also be some procedural motions that parties want to file without regard to the schedule for pre-filed testimony, including Mr. Aramburu and Ms. Volker's anything to do with the SEPA process. It doesn't appear that that issue needs to wait until pre-filed testimony is in the way of being filed and responded to. So those are the things I expect we'll talk about a little bit when we come back from the break. My clocks say it's 10:49. So I'm going to ask that people be back on the line for another roll call to make sure everybody's here at, let's go with 10:58. And we'll be back on the record with everybody enrolling substantively, hopefully by 11. So I'll see you in 9 minutes. And we'll, Mr. Botello, we can show us off the record here at 10:50, and we'll see you in 8 minutes. Mr. McMahon, can you acknowledge the applicant is back ready to go?
Applicant is here and ready to go. Thank you, Your Honor.
Mr. Harper, is the county ready to go back to our pre-hearing conference number 3?
County's ready.
All right, Ms. Reinveld?
I am, thank you.
All right, and Ms. Volkers?
Thank you, Your Honor. Ms. Volker is on behalf of the Acton Nation.
And do we have Mr. Aramburu as well?
We're ready to rumble, Your Honor. Thank you.
Okay, well, let's rumble about when is a reasonable date for filing the first round of pre-filed testimony that we've talked about a little bit in previous conferences. Mr. McMahon, you may be in the best position to know what's being filed, perhaps based on our disputed issues list that we'll get to in a little bit. When could the applicant be ready to file?
Yeah, Your Honor, thank you. This does, to me, echo considerably with prior FSEC proceedings and the experience that's been derived by the council having, and Your Honor, actually also having some experience with doing that. So the timing, the sequence looks fine and familiar to me, and it does reflect what I think has been accomplished in prior proceedings. I guess my only concern is, of course, we're probably the first party filing. There may be, I expect that TC Cares may be filing some initial testimony. I don't know. We'll have to hear from Mr. Aramburu. So that being the case, you know, as of tomorrow, we're going to start calling witnesses and make sure that everybody understands this. And I only bring that to your attention because, you know, we may need to slip and slide just a little bit as we're finding people. That's probably going to be the experience of other parties as well. So I think we probably just need to be a little bit patient with one another and you, Your Honor, as we nail this down. Some of the information or testimony may come in at different times, and we may need to have that little extra flexibility to May 31st.
All right, thank you. I appreciate that. My experience is when there's a range of dates set, that I have, I don't say never, but rarely see anybody file or play their cards and put them on the table before the actual deadline. It's just a matter of trial strategy. And so I was thinking, as you said, that Mr. McMahon, maybe a range of dates for the first round, but my quick thought is, no, set an end date, whether it's May 24th or May 31st or into June, as the case may be, to allow all parties to get their initial witnesses to at least file the basic testimony, maybe perhaps subject to supplementation. I just don't want it to affect any other party's ability to respond or reply. So that's the balance I'm trying to get here. Mr. McMahon, anything else based on what I just said?
No, Your Honor, I agree with that, and you're right. You know, parties are likely to hold off to the last day, so that's just kind of the way it happens. So, with that, we support the schedule with the understanding that you know there's going to need to be a little bit of flexibility here.
And I think I picked Wednesdays all the way through here, just to avoid the Friday afternoon 4 o'clock filing issue. But if parties would prefer another day of the week than Wednesday for this sort of thing, I'm open to that as well. Let me turn to the county and Mr. Harper and get your feedback on the schedule.
Well, Your Honor, I do have concerns about the schedule. They relate to this underlying issue, though, of how the SEPA review is being postured relative to the adjudication, and you know, that's just going to continue to be a concern of the county, I think, until that issue gets addressed head on. In particular, it seems like it's unfair and just not appropriate to have testimony deadlines when the SEPA document is still incomplete. I don't want to be argumentative about it, but that gives us a real problem, and yet we see these deadlines coming up here very, very quickly. If you know, if Your Honor has the intent that these or approximately these will be the deadlines, pending some decision on a motion, perhaps, or some other change. With that caveat, I have no other concerns. We'll have to make them work. And as between the 24th or the 31st, I really don't have a strong view one way or the other. We could make the 24th work if that's the general consensus of the rest of the parties.
Okay, I appreciate that again, Mr. Harper, about the FEIS issues, and as I suggested to Ms. Volkers and to Mr. Aramburu, if you're all of a like mind on that, and you can find any other party of a like mind on that, I would suggest as soon as possible a well thought out, well briefed joint motion, maybe with separate subcategories with each of your individual concerns as parties. But we do need to dispense with that as a legal issue sooner rather than later. So if there is a motion to stay, which is how I've seen it styled in the past, based on statute, based on WAC, based on any other controlling opinions out there, let's get that in front of me and the council sooner rather than later, so that any other parties wishing to respond can do so. Once I receive a motion and I give an appropriate time for response, I may or may not schedule oral argument on the matter, but I don't think statutorily under the Administrative Procedure Act, there's an automatic obligation to grant oral argument. So please file your pleadings if you need oral argument, make a request on the face of it. If you think there's a statutory entitlement to it or a WAC entitlement to it, call that to my attention so I can make sure not to unintentionally abridge any procedural due process rights. But I would hope to be, upon receipt of a motion, immediately sending or posting a letter saying this is the date for responses and the anticipated date for a ruling with or without oral argument. So on that issue, if we're going to get the schedule going, you're right that I'm telegraphing we're going to do the pre-filed testimony May or June and into July. And then those procedural motions, if there's any formal preservation of issues or objections that need to be substantively considered, let's get that going sooner rather than later. Mr. Harper, anything else on that topic?
No, thank you, Ron.
All right, Ms. Reineveld for Council for the Environment on these filing milestones and timing?
Yes, Council for the Environment doesn't object to the filing milestones and timing. I would just say that May 24th does seem to be a very expedited timeline for initial filing and could be perhaps insufficient time to file or serve direct testimony. I mean, particularly if we were going to have other parties other than the applicant file direct testimony at that time. So I mean, Council for the Environment would prefer that we delay the initial filing probably into late May, the May 31st deadline, or early June, and shrink the timeline between filings just to kind of avoid that expedited timeline for that initial filing.
All right, thank you. I appreciate that. And again, if all the parties think that less than 3 weeks of time between rounds of filing, particularly maybe the reply testimony briefing, could be shrunk, I'm thinking to maybe 2 weeks. I think the reason we started with this 3-week intervals was, I think, some of prior discussion we may have had about intervals in pre-hearing conference number 2, my prior experience with other adjudications, and the thought that some witnesses, their availability may be hard to get a short-term reply testimony or response testimony. So those are the reasons for the 21-day intervals, but there is room for compression, and hopefully we'll quickly be able to get to that once I hear from the other 2 parties. Ms. Volkers, for the tribe, concerns on the intervals or suggestions on when the tribe might be ready to file their first round of testimony?
Thank you, Your Honor. Yeah, a few concerns, but mostly in the hope of trying to have a dialogue here that sets up the best schedule for the group. So we do object to having testimony due at the initial deadline because it's contrary to the previous verbal direction when we first asked about this in the first pre-hearing conference, and would really just appreciate some clarification because I'm still hearing some discussion that suggests that that's an open question, but I'm reading this as the initial deadline for all parties, and we do have concerns and object to that being so soon. So I think that's my first question is how that would exactly work. The second is whether or not the response testimony is in response to, and I think this is it's a hard thing to respond to now that the issues that we had previously identified have been changed. So the question is, are we really responding on certain topics, or are we just responding to other parties' witnesses in terms of response and reply? Appreciate clarification on that. Also, we are engaging in additional discovery that is going to push back our ability to respond by the end of May on any documentary evidence or testimony from Washington Department of Fish and Wildlife. And I know we're going to talk about discovery later, but I wanted to note that and suggest that that could be filed as a responsive testimony, given that we are, that is dealing with the third party schedule. And I also just, I think that, if the approach is the one that I heard from Mr. McMahon of quote, slipping and sliding, then maybe we could make this work, but that's not how I read it. And certainly we would really appreciate a lot of clarity on that because I read this as pretty firm deadlines. And lastly, I'd say we're amenable to shrinking the reply testimony as was just suggested in order to provide more time for initial and responsive testimony.
Okay, thank you for that. Too soon for the initial date of May 24th. I'm appreciating it could go into May 31st or early June, particularly with your last comment about shrinking intervals. As far as the meaning of responsive testimony, after rolling it around with staff and with Mr. Thompson, it would appear that allowing each party to file their opening testimony essentially on any of the disputed issues they want to present witnesses on appeared to us to be the best way to accommodate every party knowing what case the others are bringing and presenting issues that they want to advocate at the hearing. By doing that, it allows every other party to respond as needed to those other witnesses that are being presented in pre-filed testimony, and then finally for the sponsoring parties to reply as necessary. So for each topic that a party wishes to participate on formally at the adjudication, that's what the meaning of the initial deadline would be, and then the response would be any other party that says, "Oh, that's an issue you're filing on. I have a response to that," and so on. I decided to make it that way instead of having the applicant simply file all their testimony and then all the other parties respond and then reply to each other as the third round, simply because the applicant has the application on file and has laid out what it thinks are the issues regarding the Horse Heaven Wind project. And that has put the parties on notice, as well as the council as a whole, as to the environmental issues the applicant has seen and all of the other varied and sundry issues that come up in the course of their application. The council's response to that was essentially the draft environmental impact statement to delve further into any of the suggested impacts from the applicant. So in my opinion and that of staff, now allowing for the purposes of adjudication, a separate track from the SEPA track, selection of issues, selection of testimony, this was the best way for everybody to have enough time and responsive rounds to best flesh that out ahead of the adjudication, that's subject to cross-examination on the various adjudication dates. So I hope that helps lay it out, Ms. Volkers, of what the intention of initial deadlines, response, and reply testimony might be made up of. Does that help?
Thank you, Your Honor. That's really helpful. And I just want to acknowledge that we're all human and responding to changes here, and that my objection was not to that overall plan. The objection is to being required to file all of our direct testimony by the end of May, given that this is a new change of course that we learned of Friday. So that sequencing makes sense to me. We're also, if that is the approach that is agreed on today, and again, I don't know that I heard that from the applicant exactly, but if that is the approach that's agreed on, we're also amenable to, I think at that point, reply is really about the opportunity for the initial testimony, those giving those initial testimony to respond to the responsive testimony, and that we would be open to discussion about how to shorten that even more or to deal with that through supplemental and cross-examination in the hearing. If that's
Okay,
what
thank you.
the group thinks is
Yeah.
necessary.
Yeah, my only concerns, we use the word agreed by the applicant. I think at this point, this is for the presiding officer, for me to set some deadlines that work for the overall schedule we've talked about today and the constraints of the statute on when to complete these things. So Mr. McMahon doesn't have any greater sway on setting the dates than any other party. So I just want to clarify that for you. I'm not consulting with Mr. McMahon to get permission to set these dates, but he has the same input on behalf of the applicant that you do or any of the other parties. Let me turn to Mr. Aramburu for any other concerns as to the timing of particularly the initial deadline for testimony and the intervals.
I want to say in the strongest possible terms, we think this schedule is inappropriate, particularly given the initial deadline for filing and serving direct testimony. I will note this matter has been at FSIC for two or more years, and that we get 3 or 4 weeks to file testimony seems to be inappropriate given the circumstances, and particularly we've had a whole change in what the issues seem to be. We submitted on March 17 our issues to the parties and to you. We had 10 issues. I don't know what happened to those 10 issues. We now have some other separate and distinct issues that have been brought up in the next section of your agenda. So we think that these dates should be pushed back at least 30 days, if not more. And given the circumstances, given the fact we haven't known what the issues are, and we really do have some questions over under number 5 as to some of the things that are going to happen here with regard to testimony. And under your double apostrophe on page 4, you said that a party wishing to present witnesses on local concerns, attitudes, and opinions should justify significance as a representative of the local area. We don't know what that means. We don't know what that means for testimony. That's something that's really brand new in these proceedings. Secondly, under site restoration and decommissioning, there's an indication here that certain issues, including SEPA and greenhouse gas emissions, which is a very important issue, will not be taken up with the adjudication unless we make a satisfactory offer of proof. Well, I don't know what that means. Is that a motion? I'm familiar with offers of proof in an evidentiary sense under the civil rules in Superior Court, but I don't know what's meant here, nor do I understand the greenhouse gas emissions are outside of the scope of FSIC might be addressed as a part of the FEIS. Where does that leave that issue for purposes of testimony due on May 24 or May 31? I'm also going to note that in the usual course of pre-hearing conferences and pre-hearing orders, we have some time set aside for discovery. We have some discovery issues that we're going to want to pursue. We have the motion practice, which seems to be indefinite at this point. We don't have in these filing milestones motions to strike, other similar things for objections to testimony. So I think this schedule we have here is unrealistic. It should be moved back for a month at least to give all the parties adequate opportunity to prepare their testimony. I can put my objections into a letter if you like, but I want them to be on record now. So, and as I indicated, some clarification down the way of what we've got to do in testimony also, I think, needs to be made here too.
All right. Well, Mr. Ramber, I appreciate all of that. You've covered, I think it sounds like TCC's concerns on all of the remaining agenda items, as well as suggesting the overall concern for the May 24th deadline. Let me speak to all of you then. And Ms. Volkers, I want to come back to the discovery piece that you mentioned later. So I'm going to set that aside for now. As I'm listening to your concerns, it sounds as though parties want as much time as possible before the initial deadline. And these dates, as I set up above in the hearing dates, those hearing dates are firm. The filing milestones for all of this in item number 4, I purposely didn't put the word firm anywhere in there because I knew that inputs today on this suggested schedule would be informing the best way to alter the intervals and make everybody's life a little easier and more humane. I think, Mr. Ramber, just responding overall to your suggestion about pushing things back a full month means that we won't have time for all the necessary motion practice and preparation for the hearing itself. I have to set a deadline, and I'm trying to make these as realistic as I can. And I've learned over years, 2 decades now as a judge, that sometimes the parties are equally unhappy, but all faced with the same milestones and deadlines. And just given the overall compression of time between now and the firm hearing dates of August 10th for the first one and the last one, August 25th, I have to make some difficult choices. And I recognize the parties might object, but that's what I have to do as the best possible job as a presiding officer and set deadlines and hold everybody to them. So let me come back to what my thoughts for a modified filing schedule might be. I think if the parties are willing to go only 20 days between initial testimony and response, and only 15 days between response and reply, that I can adjust the schedule to allow the first deadline to be June 7th, the response deadline to be Tuesday, June 27th, and stay with that deadline for reply testimony of July 12th. If the parties want to shrink the interval further, then June 7th can become a later date, and a 15-day interval could be shrunken further to move June 27th out a little bit further, probably no further than June 30th to shrink the time between then and a July 12th deadline. So the June 7th date could move to as far out as June 12th with a compression to say June 30th for the response testimony. But I don't think we can compress the intervals any further than that. So I'm just calculating in my head that June 12 to June 30 would be 24. No, that's not right. Pardon me, public math is difficult, particularly with a court reporter. So that would be essentially 18 days between June 12th and June 30th, and then only 12 days between June 30th and July 12th, and that includes a July 4th holiday weekend, which is an additional problem to accommodate. Mr. McMahon, based on the June 7th, June 27th, July 12th versus a June 12th, June 30th, July 12th, what's the applicant's preference?
Your Honor, we have been pretty careful scheduling our vacations and looking out over the fact that our summer is just going to be not a normal summer in terms of family recreation and the like, which is to say we can meet the schedule that you have outlined. It's not comfortable, but we can meet those deadlines.
Did you have a preference for that first date and the longer intervals, or the June 12th and the shorter intervals?
Yeah, I'm sorry, I haven't really digested this adequately to answer your question. All I would say is we will accommodate whatever you set.
I appreciate that. Thank you. Mr. Harper for the county?
Ken Harper for Benton County. I don't have a particular view one way or the other, Your Honor, on this topic.
All right. Ms. Reineveld?
I would prefer the June 7th or the latter date. And I also just wanted to say that looking at the schedule again, I do share Mr. Ember's concerns just regarding the fact that there are absolutely no deadlines for discovery. And so in my understanding in these matters, those deadlines should be set prior to filing and serving direct testimony. So the compressed schedule is a concern. Not necessarily the intervals between the filing deadlines, but just the fact that it's so soon and we don't have any time for discovery or motion practice.
Okay, I'm making a note here as just some thoughts on that. Ms. Volkers, anything to add or a preference on the June 7th versus June 12th and associated intervals?
Thank you, Your Honor. We do appreciate the move to June 7th or 12th. I don't, at this point, I don't think we can speak on a strong preference between the two of those. And I, again, would join in the concern about getting discovery set. And I think that would help inform our ultimate response, but certainly prefer June 7th over May.
Okay, Mr. Aramburu?
I've stated my concerns for the record. June 12 is certainly better than May 24, but we need as much time as possible. And again, setting typical pre-hearing conference orders and based upon motion practice and discovery practice is appropriate. I may make a suggestion. WCT, which I know Judge Torm you're familiar with, sets deadlines for responses to discovery, a request for information for 10 days. And the other concern that I have, there may be debate, objections to certain discovery items that might be submitted. And again, the schedule needs to take account of those possible objections. I hope there aren't any, because we think our discovery is going to be reasonable and appropriate to the proceedings. But that does need to be built in the event we do receive objections. And so, in terms of your suggestion or idea that we might shorten the time between the filing and service of response testimony, reply to testimony, we think that's we don't find the schedule to be enough time, but if we shorten those times, that would be a help to us in the final analysis. And as I said before, I'm somewhat in the dark as to what's going to happen when we get over to page 4 of the order regarding the content of testimony and these offers of proof. So I don't know where that fits into your schedule.
All right. Well, I appreciate that. And it's been a constant theme of how does discovery fit into all this? My intention was to get some basic deadlines on the schedule and then fit discovery in. I think other people might see setting a discovery deadline and then the hearing dates as the better way to do this. But again, as I've articulated, I think strongly, we have these hearing dates that had to be scheduled based on unavailability, and working backwards from them, it made more sense to me in this FSEC proceeding to look at the timing on intervals of when parties could file their testimony, and then, as I've indicated in the numbering of the pre-hearing conference agenda, turn to the discovery question. So I hear what you're all saying, and maybe in a superior court trial or some other administrative agencies that don't use pre-filed testimony, it might have been better to take up the discovery schedule first. But I want to turn to that now and skip over the disputed issues list and come back to disputed issues in a short amount of time. But let's go to number 6 on page 4, Mr. Aramburu, as you're suggesting, and I think several other parties have thought about.
Yeah, just go back to your schedule again, please.
Yes, please.
On
ahead.
page 2, and I don't mean to interrupt and take up everyone's time. I do see that your schedule includes a deadline for parties to file and serve pre-hearing briefs that would come in after the last round of testimony. And I don't know what, I guess I understand what cross exhibits are, but is it more appropriate to have a pre-hearing brief in advance of the submission of testimony so that the council has kind of a roadmap of what they're going to receive and change that deadline around? We can certainly have cross exhibits that would be a part of a schedule there, but is the council better served by having pre-hearing briefs before they start to receive all of this testimony?
Well, I'll simply answer you, I don't think so. I don't know that parties can brief issues that are simply listed on page 3 and 4 of my pre-hearing agenda without having a substantive area to brief from and to. I don't know how the parties would have any idea, Mr. Aramburu, of how to characterize their case as different from somebody else's that they have not done any discovery on and haven't seen any pre-filed testimony. So in my experience, having a substantive record starting to be created in this nature in an FSEC proceeding, and everybody starting to put their cards on the table of what the council is going to see, only after that does it make sense to me to then have a pre-hearing briefing to the council of what all this evidence is going to show through the course of them reading it and through the course of them hearing cross-examination about it. It's unique to FSEC to have this pre-filed testimony that lays out parties' cases mostly in advance and leaves the adjudicative hearing sessions to be for cross-examination and interaction. And those pre-hearing briefs for me are thought to help tee up how that interaction at the hearing should best be used and what the council members might be expected to see and hear. Having you file pre-hearing briefs before any evidence is submitted, sometimes that works in a trial setting where there's a burden of proof and there's a back and forth and the witnesses come out. But because of the pre-filed nature, to me in this particular setting, briefing with more information means those briefs are going to be of better quality and information for the council. And that's the decision I've made on why they come in this regard. As to the other deadlines that are there, the final pre-hearing conference will be a chance before that August 10th first hearing session to get all of our ducks in a row on exhibits, questions, last-minute arrangements for August 10th, 11th, and the other dates. And the post-hearing briefing is to allow time for transcripts to be processed after the August 25th date in an expedited fashion, and any other briefing on what happened at the hearing to occur. So that's why those dates are set as they are. They might be adjusted a few dates here or there. The August 8th pre-hearing conference probably won't move. The August 2nd deadline for parties to serve those additional briefs might shift to August 4th, but it's a kind of thing where people need time to read and digest before the hearing kicks off that August 10th beginning date that was firm. So with that said, let's shift over to page 4 and item number 6 and talk a little bit about how discovery is going to fit. I think based on all of your discussion from item number 4, that shifting to a hearing date, or not a hearing date, but a filing deadline of June 12th on that Monday for the first round of pre-filed testimony with an 18-day interval to June 30th for a second round, and then a final reply date with 12 days only to July 12th is going to best allow the motion practice and the discovery that the parties have been feeling a little bit uneasy about. So June 12th, June 30th, and July 12th will be the dates that we work with. So make a note of those, and when I write the pre-hearing conference order later this week, those are the dates that will be reflected. With that in mind, today is May 2nd, with hearing testimony due June 12th, you have about 40 days to get that first round of testimony done. Discovery may or may not affect your first round of testimony filing, but it probably will influence the June 30th deadline. Typically, under the civil rules, there's a 30-day response period, and under some UTC practice, that response period on discovery requests can be shortened. I'd like to see it shortened and expedited here, but I'm not sure what's realistic for the parties. We can have a short discussion about, is it 14 days to respond? Is it 21 days to respond? Or is it 10 days to respond with ongoing supplementation required? Those are the thoughts I'm having, but again, I have not been a civil litigator for a couple of decades, and my experience at that, frankly, was short. My criminal litigations, the ongoing discovery was much more just a data dump up front. Everybody knew what you were going to get, but I defer to some of your experiences on what might be done, and again, within all of the limitations that we're stuck with, given the August 10th beginning of the hearing. Informal discovery is authorized under the APA when the presiding officer says so. So let me be formal today on the record and say informal discovery can begin now if it hasn't already. As far as formal discovery, the APA doesn't give a whole lot of guidance, but I will include issues from the UTC, the Utilities and Transportation Commission, to inform whatever I'm going to do with that in the pre-hearing conference order. But I think today is a good day to flesh out some of those concerns. We've had some past practices, as they indicated, from the KV, the Kittitas Valley Wind Project. and more recently, not where I was the presiding officer, but in the Whistling Ridge and the Tesoro proceedings. And I want to limit our time on this for about another 10 minutes. So every party will get about a minute and a half or two to address their preferences. And if there is anything you want to supplement that you don't get a chance to say today, send me a letter. Today's Tuesday. Let me have it by Thursday. So Friday, when the pre-hearing conference order comes out, I can include any other concerns or respond to them that aren't voiced today that I can take into effect when I write the discovery part of this pre-hearing conference order. So I think that tees it up, Mr. McMahon. Let me start with you on discovery, and we'll go from there.
Well, Your Honor, thank you. Having participated in several of these abstract adjudications, one thing I would observe is we've often spent a lot of time talking about discovery, and then it hasn't actually ended up amounting to a whole lot as we've proceeded through the process, which isn't to say that we won't have a more robust process here. As Mr. Aramburu correctly recalled, I think at the last pre-hearing conference, we have not seen, and in Whistling Ridge, there was not depositions taken. So I think it's just really much more in line with informal discovery requests as you've outlined it, Your Honor. And we are contemplating discrete discovery requests ourselves, which, if the parties are all cooperating, ought to be a reasonably non-controversial process. But to the extent that there's controversy about it, I would imagine the parties would ask Your Honor to come in and call balls and strikes to move the process forward. So I do think this is a tight schedule, but fitting it around everything else, I think that it is the way you've laid it out, commencing essentially now, is appropriate. And there is, as I say, some probability that we may need a process to have the ALJ, police the discovery process if necessary. So do you need any more from me on that, Your Honor?
Only if there's going to be formal response times shorter than what the civil rules suggest of 30 days and ongoing supplementation.
I think there do need to be shorter response times than 30 days. And what that timing is, I'm not sure. It somewhat depends upon the nature and the volume and the characteristics of the discovery requests, I suppose. And there may or may not be issues relating to confidentiality of information and data. Probably will be some issues raised, I'm guessing, by the Yakima Nation. I'll let Ms. Volker speak for herself on that. So, this could get bumpy. I'm hoping it doesn't get too bumpy. And these professionals have done this before, and hopefully we can be professionals and handle this without a whole lot of hassle.
All right, thank you. And I do want to speak to the fact that there will be some data that will need to be protective. And Mr. Thompson and I have talked about the appropriate nature and language of a protective order that will be issued probably separately from a pre-hearing conference order, but a protective order regarding some of the wildlife, cultural, and other interests that might be substantively considered by the council in reviewing this application, but not subject to public disclosure, and working out how that's been done. And that's been done in the past as well, so we'll be drawing from that experience. Mr. Harper, on discovery response times or intervals and other thoughts about discovery in addition to the informal?
Well, I'll take your last question first. Other thoughts about discovery? Your Honor, with all due respect, I just don't see how this is workable. I really don't. I don't see how we can reasonably expect any discovery process to sync up with the pre-filed testimony expectations that Your Honor's already set, and the firm hearing dates, without elaborating, which is probably not something that you're really asking me to do at this time. I'll just add further that as to the intervals, I don't have any specific objection to the sequence of intervals, but I don't think it's going to be manageable. Despite Mr. McMahon's sort of guarded assurances, I think I'd emphasize the bumpy part of his comments. I think it is going to be very difficult to make this work, even if all parties are trying to proceed in complete good faith, which I'm sure we will.
Okay, I appreciate the difficulties of this. Again, I've said it many times today, and I've said it many times to staff as we've tried to plan the best humane schedule possible and adjust on the fly as we're doing today. It is going to be difficult. There are going to be bumps, and I'm going to have to rule on some discovery motions that get filed and do the best we can. That's all I can say, Mr. Harper. It's not this is not a pleasant thing to try to schedule within the confines of the statute and some of the. I apologize for losing the time we did between March 27th and today, but it is what it is. That's all I can say.
I understand, Your Honor, and I don't mean to be disagreeable, other than just to the extent that I'm stating I disagree. And other than that, I get exactly where you're coming from, Judge, and I'll leave it at that.
I appreciate that, Mr. Harper. I'm not taking it personally, and there are days I'd love to switch places with any of the lead litigators and let you try to be the judge. But here you go. Ms. Reineveld, thoughts?
Yes, thank you, Judge. I do think we should adhere to standard civil discovery rules for response times to discovery in this matter, considering the complexity of the matter and the issues at stake. And I agree that if we are going to adhere to those, then the schedule doesn't seem to be reasonable. I mean, June 12th still seems to be insufficient time, assuming that the parties are going to be participating in discovery. It would require the parties to serve interrogatories this week if we're going to adhere to that deadline. And there would be insufficient time for motions to compel, much less to actually receive the responses and to consider them prior to being able to present our direct testimony. It just seems too compressed, and I'm concerned about, just the ability of the parties to fully present their case. I've never seen a schedule like this before, and it just seems to be incredibly condensed, and so I have concerns, and I'm just wondering if we can consider pushing the hearing, back to mid-August or late August or something and adjust accordingly, just because I do think the parties have that right to fully participate in discovery and to consider their responses in calling direct testimony. So that's my comment.
All right, thank you. Ms. Volkers?
Thank you, Your Honor. I do share the concerns of Counsel for Benton County and Counsel for the Environment. I wanted to just ask a really specific question, though, because I'd like to leave this hearing with more clarity than I left the last on what the reference to informal discovery is versus informal versus formal. So what I understand from what you've said a moment ago is that the parties are able to utilize all discovery authorized under RCW 3405-446, which I read to include the taking of depositions, requesting admissions, and all other procedures authorized by Rules 26 through 36. And so if that is correct, if I am correct in my understanding, I just want to confirm that that is what you were approving a moment ago when you said that informal discovery is available to all parties. Thank you.
Yes, 3405-446 is the governing statute, and anything authorized under that is authorized here. And again, the subpoena power that's there, if a party makes a motion to quash a subpoena, that's something I'll have to rule upon. As far as the agency rules in sub 3, the presiding officer may decide whether to permit the taking of depositions, requesting of admissions, and all the other things. So that's within my discretion to open up rules 26 through 36, and for other parties to move if they'd like for a limitation. So that's what I meant by that comment earlier, Ms. Volkers. And so certainly the protective order is under sub 1, and discovery being available under sub 2 is exactly what I meant. So discovery is open as of today formally to go forward under 3405-446. And I'm encouraging the use of informal discovery. Just ask a party for what you want, whether by phone or by email. that's probably the best way to expedite this. And finally, if there are to be formal items used, I want to take your inputs by letter between now and close of business on Thursday, with a target for me to publish the pre-hearing conference order with any further details on the time limit for responses. But I do think it would be less than the 30 days that Ms. Reineveld referred to under the civil rules cited here in 3405 446 sub 3. And again, I want to reiterate, this is a difficult schedule, but I have a firm start date of August 10th and a wish for that recommendation to go to the governor as soon after the closing briefs are in September and the deliberations that occur. So we're already stretching, as Mr. Aramburu noted, this has been at the council for more than 2 years. There has to be an end date. And simply put, this is going to be a tough schedule. Mr. Aramburu, I'm going to turn to you on that note and ask for a very, very brief 2-minute response. Ms. Volkers, we have 14 minutes left in the schedule here, and I know I'm going to run it over to 12:15, but I can't take any further comment from you at this time. I want to give Mr. Aramburu his 2 minutes.
Thank you. We anticipate discovery. We anticipate requesting documents, information, and reports which should already be in existence. We think the response to discovery should be between 10 and 14 days as it relates to documents at least. Otherwise, I'm not going to be able to use the discovery in our testimony.
And Mr. Aramburu, I just want to take a look and say, based on the schedule I said of June 12th for an initial round of testimony, my thoughts are that parties know what they're going to file. Discovery won't affect what you're preparing for June 12th. It will affect what you're filing on June 30th. So discovery should certainly continue up until at least June 29th for people to get a response and for any tweaks to that, and perhaps be covering in the reply testimony as well what's happening there. I appreciate the 10 to 14 day response time. 10 days would have to be the minimum to give parties a chance to digest, produce, locate, and give things over under any formal discovery. But I want to take your written input, all of the parties, on when should discovery be cut off? Should discovery ongoing be allowed beyond June 30th so that reply testimony can be influenced, or is that even meaningful at that point? Is there any reason for having ongoing discovery up until the filing of pre-hearing briefs, or does that become a distraction at some point and we have to have a cutoff somewhere? So I'm interested in your answers to all of those questions in any letters you want to file to supplement what I've given you an opportunity to say today. I'm going to take a look again at some of the other experienced orders from discovery in the KV Wind case, the Whistling Ridge case, and the Tesoro matter. If there's some extract from those orders you find help make your point, is included as an attachment or an addendum to your letter. That'll be due on Thursday at close of business on May 4th. In the interest of time, I want to turn back to the disputed issues list because Mr. Aramburu in particular has asked what happened to the things that you filed to help me develop this disputed issues list. Well, they were all read, they were all considered. Everything that you've submitted to this point about how to develop the disputed issues has been considered to get us to where I am on the top of page 3 and the disputed issues list, item 5 for this pre-hearing conference agenda. These things were also consulted with staff, both on the SEPA side of the House, as well as the chair, to make sure we were addressing everything that the council expects to hear in the course of the adjudication. And again, at the end of this, the items that we just simply didn't think the statute, the application, and the WAC really gives the council a reason to evaluate as part of its siting. And this is an energy facility site evaluation council. The SEPA process is handling a number of other things, but for site evaluation, the recommendation to the governor, some issues were appropriately determined and some not. On the land use consistency matter, I want to address that the reason this is as short as it is because the council's already made a land use consistency decision That topic has left. Now it's a question of how to handle if the facility is to be sited within its proposed footprint, what conditional use criteria apply. This is different than other matters that would have been applied for after February 8th of 2021 because the county changed its code. Those issues are not relevant to this. It's anything that was in existence as of February 8th of 2021. And that's why the bullet points state what they do with regard to land use consistency. On the environmental and physical impacts, we looked at all of the inputs that came in from the parties and looked generally on what bullets and sub-bullets would be appropriate. Wildlife is a very broad issue simply because there are so many different species, other wildlife concerns that are raised both in the application and within the bounds of the DEIS. So there are a variety of topics that each party may wish to take up, but we didn't want to list a specific number of species or other wildlife habitat continuity issues. Those are up to the parties to come up with and raise as specific issues. We didn't want to give a list and feel like parties had to file specific testimony on every bird, bat, or animal otherwise that the council might list. So we gave you an example, like under threatened and endangered species. The ferruginous hawk has come up a number of times. It's just an example. Parties may wish to raise many, many more raptors or other potential impacts that they see. You may want to talk about the sage grouse. These are all choices for the parties to make. On the air quality matter, Mr. Aramburu, we weren't sure necessarily, again, given this solar and wind non-emitting energy generation that's contemplated by the application, where air quality might come in. Can you, in one or two sentences, let me know what you were thinking? Because I think you were the only party that listed air quality as an issue.
The Tri-City Cares is concerned about air quality both during construction and long-term operation. We'll be focusing on issues of fugitive dust, PM 2.5 and PM 10 emissions from the site. There is a reference to a batch plant that's found in the application, and we don't know where that's going to be, and we don't know what those impacts might be. So that would be generally the issues that we would be discussing during our air quality testimony.
Okay, that's essentially what I anticipated, but I wanted to ask to make sure whether the air quality topic needed to be narrowed or not. But it sounds like it's construction and ongoing operations. So that at least gives me and other people listening today a better idea. Ms. Volkers is going to have probably the biggest part of the testimony I anticipate on the cultural and archaeological resource impacts. There may be some historic property impacts as well. But Ms. Volkers, these will be also subject to the protective order. If you have any specific input you'd like me to address in the protective order, please include that in any submission you have by May 4th at close of business so I can incorporate that accordingly. I'm guessing that the protective order won't come out on Friday, but sometime next week, once I have a chance to digest it and speak to Mr. Thompson and possibly Chair Drew about how I'm crafting it to fit this particular project. Turning to the societal and economic impacts, and particularly the asterisks that are on local concerns, attitudes, and opinions. Mr. Harper, I think, and Mr. Aramburu raised this question about, well, what does that really mean? And how do I distinguish this from what might come up at the public comment session that will be scheduled as part of the adjudication? Probably on the evening of one of the dates that we have listed as adjudication hearing dates, possibly separate from that, because the council has to hear that testimony, but may also be able to review it. That's still to be determined and scheduled. What I wanted to do, Mr. Aramburu in particular, is if you're going to have members of Tri-Cities Cares give pre-filed testimony, that would be helpful because then they'll be subject to cross-examination, and that's appropriate to do during the adjudication. If members of Tri-Cities Cares or other local organizations, perhaps say the Audubon Society or some other recognized organization they're speaking on behalf of, the Sierra Club, for instance, if they want to give testimony, they're not a party to this adjudication. They didn't move to intervene. So they are left with the public comment and any restrictions that RCW 8050-090 sub 4 places upon them based on their prior filing of written comments. All I'm asking, and I wanted to highlight here, is that if you're going to have somebody testify at greater extent than the 2 or 3 minutes allocated at a public comment hearing, they need to have pre-filed testimony and will be subject to the cross-examination of every other witness testifying on every other topic. So that's my explanation beyond what's written in the agenda, Mr. Aramburu, on those items. Finally, turning to the other asterisk item on page, yes, we're on page 4 now. Yes, page 4 before item 6, where it says the below issues are not expected to be taken up during the adjudication. I had some good discussions with the chair and with our Attorney General, Mr. Thompson, and decided that these issues are not applicable to this application. There's not really a specific preemption. There's no petition to preempt local land use laws because there's land use consistency. There is a general preemption, but I'm not expecting briefing on that. That's what the statute says. There's nothing more to say. The Growth Management Act is only applicable as covered in the land use consistency topic. SEPA, subject to your motions and any other subsequent ruling to the difference, SEPA is a separate tract, and it's going to be completed when the FEIS comes out, and that's a separate department from the adjudication. And that would go for the next bullet as well about whether we stay this proceeding is up to a motion and a decision. As to the greenhouse gas emissions reductions, I had a lengthy conversation with FSEC staff, the chair, and the AG, and that's not something the adjudication will take up. It may not be covered by anything that FSEC does per the statute, part of its scope of the statute. This may be more likely something for Department of Ecology to take up in any comments that came in during the SEPA process. But those statements that I just made aside, explaining why those bullets are there as unanticipated, don't think we're going to cover it, not relevant topics. Again, in an attempt to make sure that I'm not unintentionally abridging anybody's due process, I stand to be corrected on any of those with appropriate briefs and a motion to have a witness on those topics. That can be filed. And I suggest if you think any of your witnesses were going to testify to any of those 5 subject matter areas that I said are off limits, file your brief as soon as possible. Let me hear from the other parties on a short response schedule that I'll state. And based on what you brief, I'll rule whether this concept of what's allowed and not allowed stands. But I don't know that any of you wish to put these topics on until you tell me you do. And when you make an appropriate motion based on the pre-hearing conference order that will come out, putting this from a suggested agenda into a rule and the order of the day for the adjudication, if you convince me and persuade me that I'm wrong in this and that the discussions I've had with the chair and our legal counsel are wrong, I'm subject to being corrected. But I have to set some bumpers. That's what I'm going to do based on these topics. It's now noon. I'm going to allow that we extend for another 15 minutes, and I hope you'll indulge me with that because I want to get basic short responses so I can anticipate what you might be filing. And then I also, before I do that, because I don't want to run out of time, I did want to give Lisa Massengale a couple of moments here to address some filing conventions that we anticipate will be published well ahead of time for your pre-filed testimony due on June 12th, so you'll know how to format that. So Ms. Massengale, if you're ready, take a couple of minutes to preview what we'll be asking the parties and requiring them to do.
Judge, did you want me to do that now?
Please do, and then I'm going to
Okay.
go back to the parties about disputed issues. I want to make sure that you get your say, and then we'll come back to the parties.
Okay, thank you very much for that. All right, so as you hopefully saw attached to today's agenda was the email list. I have received an update from the Applicants Council, and I will be updating that and sending out that corrected email list this week. If you have any corrections or revisions to this list, please let me know as soon as possible. And please do use this list when you are filing throughout this adjudication. And as you go along, if you do have corrections or revisions, please let me know so that we can keep everyone up to date and working off of the same list. I want to just make sure that everyone's really is filing to all the exact same email addresses and parties at the same time, so we don't miss anything. I have been working on some pre-filed testimony and exhibit numbering protocols and naming conventions with Judge Torum and with FSEC staff, which I anticipate will be shared with you soon. I know it had been mentioned previously using UTC protocols. I was hoping personally that we could use a simplified version of that because and it seemed to be in previous adjudications, there was a lot of confusion over using capitalized versus lowercase letters to indicate very important things like confidentiality, exempt data, and things like that. So I am working with FSEC staff and the judge on coming up with suggestions, but would love feedback once when Judge Torum feels it's appropriate to share those with you. And I didn't know if anyone had strong opinions on things like including Bates numbers on exhibits and testimony.
All right, thank you, Ms. Messingale. I would suggest that the parties, because the filing convention piece won't necessarily come out, it won't come out this week, but there'll be some further refinements. But I'm going to look based on the June 12th filing deadline, and today being May 2nd, to have something out no later than May 12th on filing conventions for all of that pre-filed testimony and exhibits. Motions, file them in any format that's familiar to motion practice, and make sure they're served per the email list that Ms. Massengale is sending out, including the filing to the FSEC adjudication specific email. But we will target that filing protocol list to come out the end of next week and hope that gives everybody 30 days to format their testimony accordingly for all rounds of testimony going forward. Ms. Massengale, anything else on filing protocols or concerns?
No, thank you, Judge Torum. I think we'll discuss internally and then the parties can have their feedback. Thank you.
All right, so let me turn back for what we have now 11 minutes left and get the applicant's feedback on the disputed issues list and my little narration there and soliloquy on why it is what it is. And then I'll come back, and I need to limit parties to about 2 minutes apiece so we can wrap up by 12:15. Mr. McMahon.
Thank you, Your Honor. The issues list makes sense to me. I do have a question though about bullet protocols. You have kind of a combination of circles and then empty circles and then squares. And so just when looking through this, it's not quite clear if some of that is like subcategories or, you know, kind of what that is. If you wouldn't mind helping us a little bit with your personal bulleting protocols, that might be helpful. Other than that, this is a lot to digest, but we'll digest and it makes sense to us. Thank you.
Mr. McMahon, I saw that the formatting everything got lined up and it doesn't look like the outline bulleting, but let me clarify that the dark black circles are the main bullets and the not filled in little circles are the sub bullets for each of those ones where they may occur to the main bullet above. Down under cultural, historic, archaeological resource impacts, it looks like that formatting carried. So you can see the bullet, sub bullet there. It looks like it also happened correctly on the local concerns, attitudes, and opinions. So please interpret the light circled bullets like bird and bat mortality or habitat fragmentation to be sub bullets of the bullet above them. And I appreciate the clarification just because the formatting got lost somewhere in the translation between my initial version of it and what got published. Does that help, Mr. McMahon?
Yes, thank you. That helps a great deal. Appreciate it.
All right. Mr. Harper?
Ken Harper for Benton County. Your Honor, I studied the disputed issues list closely, and I tried to understand the categorization, and I was able to match that up to some extent with 463, 30, 300. But I came away from it with a really strong sense that the issue statement of the county really is not adequately reflected in these topics here. And that's even giving full credit to the sort of the excluded issues, if you will. I recognize that the county's position on a couple of topics probably will be categorized as ones of law that can be addressed through motions, and probably will not be expected as topics on which we offer testimony. But other issues that the county feels very strongly about, in fact, some of our key issues, as stated in our March 9 issues list, I just can't find on this disputed issues list, even if I read these fairly generously. To give an example, Your Honor, one of the county's chief concerns is that the proposal represents a landscape-wide change in planning policies and frankly commitments the county makes regarding preservation of agricultural land for agricultural purposes. That's not a land use consistency topic. That's not an agricultural industry interest under societal and economic impacts. It's not simply a matter of cumulative impacts, and it really isn't just a question of site restoration and decommissioning. So I guess, Your Honor, I don't want to, I'm sure Your Honor doesn't want to debate sort of, the ins and outs of all of these, but my question would be this: is there a mechanism that you would allow for a party to supplement or further comment on the disputed issues list to the extent that it's not already settled in this list?
I think that's a fair question, Mr. Harper. And I'm looking at your March 9th letter now and the 5 bullet points that came in as the for the county item. My styling of the exhibit or the disputed issues list, I think, was designed to allow you to elaborate on those specific issues that you stated, but give broader latitude, frankly, and having a vaguer
Okay.
1 or 2 word item. My only caveat is I'm trying, by using this disputed issues list, not to overly limit, but also not overly broaden the subject matter for the adjudication. Any party that files initial round of testimony that's well outside the scope of what I've listed in the disputed issues list and will write up in the pre-hearing conference order so that it's official might be subject to a motion to strike.
Okay.
But if another party doesn't move to strike this in some aggressive fashion, I've seen it both ways in adjudications where the testimony is what it is, and other parties just say, okay, we'll respond in cross-examination to narrow things down for what's appropriate rather than motion practice. I encourage you to submit what you think goes within the bounds of the disputed issues list. And if you think I've unfairly limited it, submit your testimony subject to a possible motion to strike. I'm not saying that I won't sua sponte say, whoa, that's way outside the bounds of what we expected. And I might send out a bench request saying, can you show me where this fits in the disputed issues? But I don't intend to ignore any of the issues that were stated by the parties.
Okay.
Subject to the caveat of what I said are not in the realm of FSEC's scope of review. Does that help, Mr. Harper?
It does, Your Honor. And I, again, Your Honor, I can understand how you have carved out the asterisk below issues as really just sort of categorically different from the FSEC adjudicative mission. I totally understand that. My anxiety was just when I couldn't slot sort of our key substantive issues in another area. But if we can understand that this is meant to be broadly construed, and if we don't run afoul of the asterisk issues and we're otherwise somewhere on the list in some guise, then we'll be allowed to proceed subject to a motion to strike. I think that's probably fine, particularly with the colloquy that we're having right now. So I'll leave it at that, Your Honor. Thank you.
Yeah, it's a difficult thing to say. Please broadly construe the issues list, but narrowly tailor your testimony. And the cognitive dissonance I have just by saying that back out loud is going to require some excited moments later this afternoon. But I feel your pain, and I'm just trying to do the best I can, Mr. Harper. All right, let me shift to the Council for the Environment.
And generally, the Council for the Environment's issues specifically related to habitat and wildlife are reflected in this list. So thank you. We also raised just the point in regards to greenhouse gas emissions and the reductions analysis. And, you know, the FSEC statute seems to generally contemplate that FSEC should recognize the need for increased clean energy facilities that could potentially reduce emissions and balance that with other environmental impacts of the project. So as Council for the Environment noted in our comments, there wasn't any analysis in the DEIS regarding kind of the need for the project in light of meeting these clean energy goals, or, you know, how that project would fit into the needs, the pressing needs for increased energy facilities and just the emissions reductions resulting from the project. And we think that would be important for the council, you know, to consider in making their recommendation to the governor. So I think it would be helpful to know whether or not this analysis is going to be part of the FEIS before we file a motion or advocate on this issue. It says might be addressed as part of the FEIS, but this, again, it would be helpful to know if this is going to be addressed.
I appreciate that discussion of that topic, particularly because you referenced the policy goals set out in the statute and other things that FSEC is designed to do. The discussion we had on pushing that out from the scope of testimony for the adjudication was based a lot on the fact that it's statutory policy, not something to be testified to. That was taken care of at the legislature's level and as their statutory direction to the scope of FSEC. The better place for those items might not be in the development of evidence, Ms. Reineveld, but in the post-hearing briefs at some level pointing out how this application and proposed project does or doesn't forward those policy goals that are set out very well in the statute. So the adjudication itself shouldn't have any evidence presented on that. It should simply be arguments based on what evidence is submitted to the council and how it does or doesn't meet policy goals. I'm simply trying to avoid cross-examination on whether or not there's a need, cross-examination or not on the greenhouse gas impacts. That's outside the citing issues. There are policy subjects in the overall FSEC statutory scheme that are just outside the scope of an adjudication. As to the question of whether it might be addressed in the FEIS, I simply don't know. And I think some of my comments in March were taken as a point where I was trying to be, I wasn't trying to, but I was interpreted as trying to influence the pace of the SEPA process. So backing out from those comments from March and staying in my lane of the adjudication means that's not it's above my pay grade, or at least outside my scope of what I'm doing in the scheme of the adjudication. So I hope that's helpful as to where those things fit into the overall application review process, but distinguished from the scope of the adjudication.
Yeah,
I
appreciate
go
that.
ahead, Ms. Reineveld.
No, I just said I'll appreciate that and then consider it and then follow up if necessary.
All right, thank you. Ms. Volkers and Mr. Aramburu, I want to come to you before we close, but respecting that I'm already at 12:15 and stretching the parties' allocated time today. Ms. Volkers, let me hear from you on the disputed issues list.
Thank you, Your Honor. And it sounds like we'll need to follow up further by the letter that you requested. But I do want to say on the record that we strongly object to the way that the disputed issues list has been published, because it's contrary to Your Honor's previous verbal direction and the fact that the parties spent considerable time trying to meet the court's direction, submitted issue statements and revised issue statements in response to the direction to look at certain examples, which we did, and mirrored, if not identical, issue statements that have been used in other adjudications. The applicant had 6 weeks and did not object at all to the issues that were submitted by any of the parties, and including Council for the Environment's issues, which were actually agreed to by all parties in the last pre-hearing conference. I'm also concerned about the exclusion of greenhouse gas emissions or any taking of evidence around that, given that RCW 8050-010 requires FSEC to act in accordance with certain premises, including the need to preserve and protect the quality of the environment. So I'm concerned that we would be limited on the ability to bring evidence about that, and unclear on how we would be able to argue about that in briefs. And frankly, just the fact that the outcome of this is meant to lead to findings of fact and conclusions of law. That was the goal, certainly by our team and representing the Aqua Nation, and I believe by others, in making good faith efforts to put issue statements clearly in a way that can be argued succinctly. And I'm concerned that this new list is a step back from clarity in favor of the applicant without any objections or advocacy on their part to do so.
All right. All of those items are noted. I'll simply say that I'm not attempting to deviate from previous guidance, but take all of the inputs and work with them. And there's certainly been no quarter given to any other party that's not being given to everybody else. There's no intent to treat any party, particularly the applicant, with any better favor than any other party, Ms. Volkers. I'll just say that for the record. All right, Mr. Aramburu, your thoughts on the disputed issues list, and please, I appreciate if you'll keep it at least as short as Ms. Volkers did.
Okay, I will associate myself with the comments of Ms. Volkers and Mr. Harper. In particular, on March 17, we submitted a list of 10 disputed issues following your direction. We did not hear objections to those. That's what we've been operating from. And now we're very confused as to whether these issues will be permitted or not. In particular, we are concerned that the issue of the overall scope and scale of this project is now a sub under local attitudes and opinions. We intend to present testimony on that issue as we've identified in our previous issues submitted on March 17. So I do not see that what you're saying here is going to prohibit that, but that is a matter of concern. And then regarding site restoration decommissioning, you said a satisfactory offer of proof. I understand that to be, as we've discussed it here, it's not really an offer of proof, but it is a motion before we would be permitted to submit testimony on that issue, particularly the greenhouse gas emissions. So those are my particular concerns that we have now. So I want to be brief about that.
Thank you. I want to clarify one thing. You mentioned the site restoration and decommissioning is limited. You listed that as an issue, and that is above the line of the asterisks. So I want to be clear, even though there's no sub bullets underneath that, I think the formatting compressed things and may have, as Mr. McMahon said earlier with the bulleting, be confusing. But the below issues, anything below those asterisks, those are the 5 that I went over, from preemption through greenhouse gas emissions, that would need the offer of proof. Site restoration and decommissioning is definitely in play, and you can offer testimony on that, Mr. Aramburu, without any need to further justify. Does that help?
Say that once more, please.
The site restoration and decommissioning topic is fully in bounds.
Okay, I understand that, but the issues that I'm talking about are not site restoration and decommissioning. The SEPA issues, the issue of the scope and scale of the project, are not related to site restoration and decommissioning.
I may have misunderstood what you just said. I thought you mentioned site restoration and decommissioning in the same breath as those, but I wanted to be clear, you don't need to justify the relevance of that particular topic. The other ones, I stand by what I said earlier and what's listed in those 5 bullet points, that those are subject to demonstrations of relevance and the scope of the FSEC adjudication, that any party that wants to prove that I'm wrong on that, file the motion to include it. If necessary, other parties can respond, and then I can, based on your briefing and your justification, make an appropriate ruling. And again, it may be different than what I've said today, but it stands to be the burden of persuasion, if not production, as to why that would be relevant and why the council should consider that within the scope of an adjudication. So
Okay.
I intend to issue a pre-hearing conference order on Friday in the late afternoon, likely after I have a conversation with the rest of staff based on how things went today and what I hear from all of you by close of business on May 4th. At this time, I'm not setting another pre-hearing conference order or pre-hearing conference number 4. If there are motions to be filed, as I said elsewhere in the agenda, please move on those quickly and promptly. If there are procedural motions that you're going to file, send them in as soon as and file them as soon as possible. We'll set again, I'll remind you, the June 12th date for initial round of pre-filed testimony to give you as much time as possible, with a compressed 18-day interval to June 30th for the responses, and then the 12-day interval on July 12th for the reply testimony. That'll all be captured in writing in the pre-hearing conference order. I thank you all for the input today. I want to touch briefly on item number 7 and just go quickly around the table and say, if there's something that you thought we were going to cover today that wasn't covered, I want to just note it, and then as needed, schedule a 4th pre-hearing conference to address those. We just don't have time to address anything else today. Mr. McMahon, was there anything else that the applicant needed addressed in the next little bit of time?
No, Your Honor, thank you.
Mr. Harper?
Yes, Your Honor. I've listened to the further dialogue about disputed issues, and Your Honor, I just remain uneasy about the way it's expressed. I wonder if Your Honor would consider adding a clause under paragraph 5 where you're characterizing the disputed issues list. If you might be willing to state in your next pre-hearing order that this list is not intended to be exclusionary, and just as you've explained to me and to the other counsel, that a party may nevertheless seek to introduce testimony that clearly is within the realm of the topics subject to potentially proving up its relevance. And it would just make me feel a little better, Your Honor, if I understood that this is not meant to be and won't be construed to be an actual bar to the submission of potentially very important evidence. I'll just leave with that, Your Honor. If you would consider that, the county would very much appreciate it.
I have got a 3 asterisk note to think about that, Mr. Harper. I appreciate it.
Thank you, Your Honor.
Ms. Reineveld? All right, Ms. Reineveld, anything else that you think we didn't cover today that needs a coverage at a future pre-hearing conference?
Well, I think there are some unresolved issues, but nothing further at this time. I think those have been stated on the record. So thank you, Judge.
All right, thank you. Ms. Volkers?
Nothing further today, Your Honor. Thank you.
All right, and Ms. Volkers, any timely input from you and the Yakima Nation on the scope of the protective order? I'm happy to take those as you have time after the May 4th close of business for these other issues that we mentioned on discovery. Turning to you, Mr. Ramber, any other topics? Go ahead, Ms. Volkers.
So you would not like that addressed in the letter that we're going to need to now submit by Thursday? That you would like that addressed separately?
That protective order is targeted to come out by May 12th. So I don't need it necessarily on May 4th, but some timely, as you choose to file it and you have time early next week, would be more than helpful.
And you would like that in a motion, not in a letter form?
Oh, no. Your description on what the protective order should contain doesn't need to be in a motion. It could be, but I think at this point, until the order comes out, If you had a motion to amend it, that might be good for motion practice. I'm trying to keep this as informal and unburdensome as possible if you believe that, but that's why I want to give you more time to think about the protective order item than just essentially 48 hours.
Thank you, Your Honor. We will do as much as we can by Thursday and appreciate the opportunity to follow up as necessary afterwards.
All right, thank you. And Mr. Aramburu, any other items for a future pre-hearing that weren't thought of or addressed today?
I think we've had a good discussion today. Thank you for your attention, Mr. Torm.
All right, thank you, Mr. Aramburu. It is 12:26. I'm going to adjourn the pre-hearing conference at this time.